Check, check.
Good afternoon. I am now convening the exceptions hearing in the case of Palm Beach County School Board versus Victor Lopez, DOA case number 22-3035 TTS, June C. McKinney. This case involves the suspension and termination of Victor Lopez. Ms. Bellata, will you please take the roll?
District 1, Barbara McQuinn.
Here.
District 2, Alexandria Ayala.
Here.
District 3, Karen Brill.
Here.
District 4, Erica Whitfield.
Here.
District 5, Frank Barbieri.
Here.
District 6, Marsha Andrews.
Here.
And District 7, Edwin Ferguson, who is absent.
Also joining us on the dais today is Inspector General Teresa Michael, Senior Attorney Sean Fahey, and General Counsel Sean Bernard. I will now turn the meeting over to our General Counsel, to the Board, Shantoya Bernard, and Ms. Bernard will provide an overview of the hearing.
Thank you. All right. I know you have all reviewed the records, which included a letter to you outlining detailed information regarding the scope and parameters of this exceptions hearing today. I will go over where we are procedurally, the board's charge and responsibility in exceptions hearing, and the legal standard for voting. After I go through all of the information, I will then entertain any board questions before we proceed. You will then make some decisions regarding this case. As an overview, this case is before the school board for review of the recommendation for suspension and termination of Victor Lopez for policy violations related to inappropriate interactions with students, physical and verbal, failure to supervise, safeguard students, and failure to use professional judgment. Mr. Lopez requested a Division of Administrative Hearing, DOA hearing. He was represented by attorney Nathan Sowell at the hearing before Administrative Law Judge June McKinney on June 14th and 15th of 2023. Ms. Middleton and Ms. V. Danielle Williams represented the superintendent at the administrative hearing, and they do so as well today. As provided by law, since the ALJ issued the recommended order, I have not conferred with Ms. Middleton or Ms. Williams substantively regarding this case. After the DOA hearing, the administrative law judge, ALJ, concluded that Mr. Lopez committed misconduct in office under Rule 6A-5.056 to B and C of the Florida Administrative Code, which provided just cause for discipline. The ALJ concluded that Mr. Lopez did not use his best professional judgment in violation of Rule 6A-10.0811B and did not provide the best example for his students in violation of School Board Policy 3.024A. By his behavior of name-calling and flicking students. The ALJ also concluded that when Mr. Lopez mimicked a choked hold, his action was an unnecessary physical interaction with a student, including horseplay, in violation of School Board Policy 3.025A3. The ALJ further concluded that Mr. Lopez was in violation of School Board Policy 1.0131 for not carrying out his assigned duties in accordance with the school board policies. The ALJ recommended that the board enter a final order issuing a 30-day suspension without pay, 1-year probation, and completion of professionalism classes. The ALJ rejected the superintendent's recommendation that Mr. Lopez's employment be terminated. The superintendent timely submitted exceptions to the recommended order. He is now before you on 7 exceptions and is requesting that the school board grant those exceptions and thereby enter a final order upholding the superintendent's recommendation for suspension and termination of Mr. Lopez's employment. The board's review and discussion today is limited to the specific subject matter of the issues presented by the superintendent and his exceptions. The school board has very limited and specific parameters for these hearings as outlined by the Florida Sections 120.569 and 120.57 and the Florida Administrative Code. These have been outlined in greater detail in a letter to the board, which counsel for respondent also received a copy of before this hearing. After any presentation of arguments in support and in opposition to the exceptions, board members may ask questions or engage in discussion. You are not required to do so if you have all the information you need. The board will now hear argument from the parties on the exceptions. Ms. Middleton is allotted 15 minutes to present arguments. She may request to reserve any portion to reply to Mr. Sowell's arguments. Mr. Sowell is then allotted 15 minutes to present arguments. If Ms. Middleton reserved any of her initial time, she then presents for the remainder of her time. Time clock must be set. No additional time will be provided. And with that,
Ms. Middleton, you now have 15 minutes to present your case, after which Mr. Sowell will have 15 minutes to present.
Good afternoon, Chair Brill and Vice Chair Barbieri, board members. I'm Jean Marie Middleton, and I would like to reserve 3 minutes of my time for rebuttal. A parent reported to the principal of Boca Raton Middle School that teacher, Mr. Lopez, placed his son in a chokehold during the 6th period class. Principal Lee immediately spoke to several of the students in the classroom and found that that had been corroborated. She sent Mr. Lopez home for the day and contacted the Office of Professional Standards to begin an investigation. The OPS investigator took a random sampling of 6 students from each of Mr. Lopez's classes to undertake his investigation. During his investigation, he learned that not only had he inappropriately placed the student in a chokehold, but that he had also flicked students, that he had also provided inappropriate nicknames and threw markers in students' direction to get their attention. His inappropriate interactions that were reported and corroborated in each of the 6 classes included a chokehold. The ALJ found that the actions of Mr. Lopez were not an actual chokehold because he didn't apply any pressure. She indicated that he mimicked a chokehold to celebrate a student. Mr. Lopez specifically testified that while his actions mimicked a chokehold, any observers might think that it was a chokehold. Since he did not apply any pressure, it was only a mimicked chokehold. With regard to flicking students, most all of the students testified that he would come up to them and flick them either on their head, on their shoulder, on their back to get their attention when they were not paying attention. And also, he would throw markers when the students were not paying attention. Now, Mr. Lopez testified that he wasn't really throwing the markers at the kids to get their attention, but that he was throwing them in the trash can. The ALJ found that the more credible evidence was that several students testified that they were thrown in the direction at the students to get their attention. With regard to the inappropriate nicknames, some of the names that he used included Four Eyes, the student who wore glasses, Oprah for students who talked too much, quote unquote, Beavis, Shanae, Ken, Barbie, Will Smith, Thing 1, Thing 2, Dipstick, and Knucklehead. When asked why she thought Mr. Lopez called her Shanae, student AH specifically said, and I quote, "Truthfully, because I am black, and Shanae is a character from an old TV show. Her archetype is like a stereotypical black girl, loud, kind of mouthy." Student BW testified that Mr. Lopez would call students knucklehead if a student got a question wrong. He further testified that he was very fearful and he did his best not to get a question wrong because he did not want to be called a knucklehead. Student PW specifically testified that Mr. Lopez made jokes all the time and called people names that he thought was funny, but they didn't think those names were funny. He said he was called Ken Doll, and he did not like it. Now, Mr. Lopez admitted that he would call students knucklehead, but he explained that he was only using the term in an endearing way, trying to provide positive reinforcement when the student would answer a question wrong. And that was found in the recommended order at pages 7 through 10 and page 12. However, notwithstanding his attempts at humor or to be endearing, the students did not appreciate such humor. Even if one student didn't appreciate it and one student's educational environment was interrupted, that would have been too much. In this proceeding, the administrative law judge specifically made the finding of fact and conclusion of law that there is no question that Lopez's poor judgment of referring to students by nicknames, by flicking students with a light tap to get them to pay attention, and mimicking a chokehold without pressure and celebration were inappropriate interactions, not displaying the best professional judgment, because students should be addressed by their names and not touched. Now, it's important to note that in her conclusion of law, she specifically left out the throwing of markers, but that was a finding of fact that she had already made in the recommended order. And that's important because prior to this recommendation for suspension, just 3 months prior, Mr. Lopez had served a 10-day suspension for hitting students with a ruler that had a tennis ball attached to get their attention. He was then told that he was not to engage in inappropriate physical contact with students. Now, this is a case of progressive discipline. The judge ruled that, and we'll look at that when we talk about the exceptions, the board believed that he had violated School Board Policy 3.02, which addresses abuse of children. And it specifically says that employees are not to expose students to unnecessary embarrassment or disparagement. Well, we know at least 3 students felt that they were embarrassed and disparaged, that they should not engage in unnecessary physical interaction with students, including horseplay. The administrative law judge ruled that it was horseplay because he was just mimicking a chokehold. Under the Florida Administrative Code, Section 6A 5.056, which talks about the criteria and what will be justification for personnel discipline, just cause is demonstrated by misconduct in office. And misconduct in office is demonstrated by a violation of the Code of Ethics for the education profession, by a violation of an adopted school board rule, such as Policy 3.02, our Code of Ethics, and behavior that disrupts the student's learning environment. We've seen that all of these were present during this case. What can you do in this proceeding? You can accept the ALJ's findings of facts and conclusions of law that we have taken exception to in paragraphs 25, 27, 35, 40, 44, 58, 61, 63, 81, 85, and 106, as well as the final recommendation. You can reject the ALJ's recommendations and substitute your findings that the next step of discipline is, in fact, termination. You can also find that your action of terminating Mr. Lopez was made pursuant to your authority in School Board Policy 3.27 and the Administrative Code. Given that the conclusions of law in the recommended order were mixed with determinations of fact and law, and they were imbued with policy considerations, then pursuant to recent appellate court decisions in the Alatson case, you and the courts will defer to your judgment in this instance. What are we asking for you to take exception to? The petitioner took exception, or the superintendent, to paragraph 85 of the recommended order. In paragraph 85, she found that students did not take offense nor thought that the nicknames were derogatory. Well, that's contrary to the record evidence. In paragraph 102 and 103 of the recommended order, she indicated that the school board's contention that just cause existed to terminate him due to inappropriate physical contact and inappropriate statements after having been given a reasonable directive was not found. It was her opinion that just telling him not to engage in inappropriate physical contact was not enough. We don't think that an educator has to be told and enumerated exactly every type of physical interaction that is inappropriate with students. With regard to our exception 3 to paragraph 104, Even though Lopez used poor judgment in referring to students by nicknames, she found that it was not malicious, it was not derogatory, it didn't cause embarrassment, nor was it disparaging. Well, we've heard from 2 students that they did feel that it was disparaging and it was derogatory in their eyes. Exception number 4 is with regard to paragraph 105, which we've already talked about in exception 2, and also with regard to our exception 6, where she indicated that termination is too extreme a penalty under the circumstances. Well, termination is not extreme. It's the next level in progressive discipline. He already had a suspension for like actions. And then lastly, the recommendation that he should only serve a 30-day suspension without pay, a 1-year probation, and engage in professionalism classes, we believe is not enough. That you, as the board, pursuant to Florida statute section 12057-1L, you are authorized to reject and modify the ALJ's conclusions of law when you find that your substituted conclusions are as or more reasonable than that which you are taking exceptions to. So what is it that the superintendent would like for you to do? To grant all 7 of the exceptions and to uphold Mr. Lopez's termination. Thank you.
Mr. Sewell, am I saying your name properly?
It's Sewell.
Sewell. Mr. Sewell, you may proceed.
Thank you. I'll begin just by talking about the different exceptions that the superintendent's council just discussed, and I'll go in turn. So we'll start with the exception number 1. This specific exception, what they're trying to assert is that the students did take offense to the various statements and actions by Mr. Lopez. That's not the case. There's competent evidence otherwise. The ALJ in this case captured the essence of the situation, recognizing that Mr. Lopez's use of nicknames as a result of perhaps misguided humor was critically devoid of any malice. Importantly, the ALJ discerned, based on the weight of the evidence, that the students largely did not perceive these nicknames as offensive or derogatory. To be more specific, PW's testimony, in PW's testimony, he expressed discomfort with being nicknamed Ken. But that doesn't equate to him finding the term offensive or derogatory. Discomfort with the nickname doesn't necessarily mean that it's offensive or harmful. BJ's testimony and recollection, particularly regarding the nickname Knucklehead, was assessed in context. As per the ALJ's determination, Lopez's intention was endearing, aiming at positive reinforcement rather than derision. With respect to AH's testimony, AH's insights into her nickname, Shanae, were juxtaposed with her own admittance of classroom behavior. The ALJ's conclusion reasonably encapsulates this duality of perspective. The school board may have general reservations about the use of nicknames. That doesn't render the ALJ's specific conclusions regarding Mr. Lopez's intent and the students' perceptions unreasonable. The generalized stance of the school board does not vitiate the ALJ's specific findings derived from the full evidentiary record, which states it is the hearing officer's function to consider all the evidence presented, resolve conflicts, judge credibility of witness, draw permissible inferences from the evidence, and reach ultimate findings of fact based on competent, substantial evidence. If, as is often the case, the evidence presented supports 2 inconsistent findings, it is the hearing officer's role to decide the issue one way or another. The agency may not reject the hearing officer's finding unless there is no competent, substantial evidence from which the finding could reasonably be inferred. And that's Packer versus Orange County School Board. That's a 5th DCA decision. Paragraph 85, as articulated in the recommended order, embodies a well-reasoned determination based on the entirety of the evidentiary record. It balances the weight of the credible evidence of the individual testimonies with overarching findings, rendering conclusions that are both reasonable and grounded in substantial evidence. In light of the competent and substantial evidence supporting the ALJ's finding of fact, the respondent respectfully urges that the petitioner's exception number 1 be denied. Lastly, with regards to credibility determinations, which is, I think, what we're really talking about with respect to this exception, deference should be given to the ALJ, and the school board should not be permitted to reject or modify that determination. With respect to petitioner's exception number 2, petitioner is taking exception to paragraph 102 and 103, which details and analyzes the school board's allegation that Mr. Lopez alleged violation of school board policies and state laws after the specific directives given after prior disciplinary incidents. Respondent here asserts that the ALJ correctly found that the recent actions of the respondent are distinct and markedly different from previous behavior, that being the ruler incident. The ALJ, possessing the advantage of evaluating the evidence and assessing the credibility of witnesses, found significant differences between the earlier incidents involving a ruler and a tennis ball and the recent alleged infractions. The ALJ made factual determinations based on the record as a whole, not just that the specific incidents the petitioner cites. The petitioner's exception selectively presents evidence to depict more continuous behavior, but it fails to capture the nuances that the ALJ's conclusion actually considers. The nature, context, and intensity of the more present actions differ from the earlier ones. The respondent's mimicking of a chokehold in celebration cannot be equated with the inappropriate touching of a student. One has an educational setting context with no malicious intent, and the other has implications of inappropriate behavior. Furthermore, the ALJ noted the overall perception of the chokehold when including the reactions of the students. Specifically, PW testified that Lopez didn't intend to harm them, and PW is the student that was placed in the chokehold, for reference. EK testified that the chokehold was not serious. SY's testimony purported that Lopez was joking, and GG's testimony was that the chokehold was no big deal at all supporting a finding that Mr. Lopez's actions were without malice and caused no harm and different than the previous incidents. Additionally, in the ALJ's recommended order, the ALJ made a specific finding that the actions described as a chokehold by the petitioner did not constitute a chokehold, adopting the following description of what a chokehold is: a way of holding someone with your arm tightly around the neck so they cannot breathe easily. There's no evidence whatsoever at all in the record that there was an actual chokehold here. There was no pressure, there was no tightness around the neck. It was done wholeheartedly in a playful manner. Given these findings, the petitioner's exception seeks to draw a direct line between distinct actions, oversimplifying the contextual, nuanced differences between them. The ALJ correctly assessed the full record and found that the recent actions of respondent were not of the same character or gravity of the past incident. As such, the respondent urges the agency to reject petitioner's exception to number 2 and adopt the ALJ's well-reasoned conclusions. With respect to petitioner's exception number 3, the petitioner raises an exception to paragraph 104 of the recommended order by alleging an omission of certain facts and challenges the ALJ's conclusion, drawing from the whole evidence. Respondent disagrees with this exception. While the recommended order did not explicitly mention the action of throwing markers in paragraph 104, the act was duly noted in paragraphs cited by the petitioner. The ALJ evaluated the gravity, intent, and frequency of this behavior and determined it to be not malicious in nature. The isolated actions of throwing markers to garner attention when contextualized differ from an intentional act causing harm or injury. Likewise, the ALJ weighed the testimony of the students and the respondent regarding the act of flicking. The act, while perhaps unorthodox, was not found by the ALJ to be inherently harmful, especially given that no student testimony indicated harm or emotional distress from the action. Furthermore, as stated in the response to the previous exception, Mr. Lopez admitted to using nicknames such as knucklehead. He contextualized the usage as endearing in an attempt to attempt at positive reinforcement. As with petitioner's exception number 1, deference should be given to the ALJ's ability to assess the credibility of the evidence, and the ALJ's substantial conclusions in paragraph 104 were reached through evaluation of the entire record. The petitioner's selective highlights do not overshadow the broader context captured by the ALJ. Thus, respondent requests that this board reject the exceptions to exception number 3.
You're completed? You're finished?
No. I'm sorry. No, okay.
Continue.
With respect to exception number 4, petitioner's exceptions surround paragraph 105, which centers on the assertion that respondent disrupted the student's learning environment. The ALJ correctly here considers the holistic context, interpreting that while students may have perceived some lessons as underwhelming or tangential, this does not equate to a universal disruption of learning environment. The individual perceptions of a few students about the efficacy of Lopez's teaching methods do not necessarily translate into a violation of the school board policy. As the ALJ detailed, despite the unconventional techniques employed by Lopez, no evidence was presented indicating that he acted with malicious intent or failed to safeguard students. Students' subjective feelings about teaching styles should not be confused with the definitive objective measure of instructional disruption. With respect to exception number 5, petitioner's exception to paragraph 109 focuses on the ALJ's determination that termination was not the appropriate disciplinary action for Lopez based on the presented facts. The ALJ's decision was underpinned by the lack of evidence showing Lopez repeated previously disciplined behavior or posed harm to students. The finding was in line with the discretion provided by Article 2, Section M7D of the Collective Bargaining Agreement, emphasizing that termination is not a mandatory outcome. While the petitioner cites paragraph 106's conclusion about Mr. Lopez's professional misconduct, that doesn't automatically justify termination. Professional misconduct can be addressed through various disciplinary actions, not just termination. Furthermore, the ALJ's discussion of progressive discipline in paragraphs 107 and 108 underscores that escalation to termination is not the only or inevitable outcome in this case. It's crucial to recognize that the distinction between the violation of policies and the proportional disciplinary action such a violation warrants. The ALJ's conclusions in paragraph 109 mirrors this distinction and seeks to ensure fair and just treatment. With respect to exception number 6, petitioner's exception to paragraph 110 revolves around the conclusion that termination is an overly harsh punishment in this situation, much like exception number 5. The ALJ reached this conclusion based on several mitigating factors. Number 1, Lopez's non-aggressive behavior, the lack of danger or harm to students, the students achieving their educational objectives, Lopez's cooperation throughout the investigation, his acknowledgement of his wrongdoings, and his longstanding service to the district. For reference, Mr. Lopez has been employed by the district for 19 years. The petitioner leans heavily on student testimony and prior conclusions of law to justify termination. However, the gravitas of student testimony doesn't necessarily dictate the extremity of the disciplinary action. The ALJ in paragraph 110 has balanced the evidence with Lopez's history and cooperation, suggesting a multifaceted disciplinary approach that focuses on rehab rather than punitive measures. The ALJ's recommendation for a structured disciplinary action comprising a suspension, probation, professionalism classes, and a specific behavioral directives aligns with the intention of preserving an educator's career while ensuring safety and well-being of students. To be modified or rejected, an agency must generally show that the applicability of the law is more reasonable than the ALJ's. That's section 120.57 of Florida statutes. The respondent urges the school board to uphold the findings and recommendations of paragraph 110. With respect to exception number 7, the petitioner has taken exception to the recommendation of the ALJ for a structured disciplinary approach for Mr. Lopez, asserting that it deviates from the board's prior decision to terminate employment. Conversely, the ALJ's recommendation is derived from a detailed examination of all of the evidence, the nuances of the situation, and Mr. Lopez's history. While the petitioner leans on the violations highlighted in paragraphs 25, 27, 35, 40, 58, 61, 63, 81, 85, and 106 of the recommended order, many of the responses to exceptions have discussed those statements in detail and argued in favor of the ALJ's more comprehensive and reasonable determination. Furthermore, the ALJ's findings were supported by competent, substantial evidence, and the ALJ's findings were of a character not infused with overriding policy considerations. Therefore, the petitioner's recommendation for termination should be denied in favor of the ALJ's recommendation. Conversely, if it is determined that the ALJ's findings were of a character infused with overriding policy, respondent argues that ALJ's policy considerations result in a more reasonable penalty and outcome than petitioner's recommendation for termination. In support of this policy consideration, the ALJ highlighted that disciplinary actions should serve two purposes, punitive and corrective. The ALJ recommendation aims to strike a balance between these two, ensuring Mr. Lopez acknowledges his wrongdoings and undertakes corrective measures. In defense of this recommendation, the ALJ acknowledges Mr. Lopez's full cooperation and admittance to his behaviors at all stages of this matter, from investigation through testimony at the final hearing, and taking responsibility and accountability for his actions and omissions in compliance with School Board Policy 3.024F. Additionally, it is essential to consider the spirit behind School Board Policy 3.27 and FAC 6A0562. Ultimately, the goal is to to foster a safe and conducive learning environment while ensuring justice and fairness in employee relations. At no point did any of the students testify that they felt unsafe in Mr. Lopez's classroom. And the overwhelming sentiment of the students' testimony support that Mr. Lopez had no ill intentions in his actions. Mr. Lopez has dedicated 19 years of his life as a district employee and obviously cares for his students and their success above all else. Thank you.
Ms. Bernard?
Thank you. I just want to note for the record that Mr. Ferguson has entered the hearing. I also want to state for the parties and to Mr. Ferguson, who's entered the hearing, that the parties would ultimately, before the board discusses, would need to be presented with whether or not they have any objection to Mr. Ferguson voting on this issue. And then, of course, Mr. Ferguson on his own could make a determination not to vote on this matter, but having come into the hearing at this point in the hearing, I think it should go to the parties to determine if they have any objections to Mr. Ferguson voting on the matter. And then, of course, Mr. Ferguson can represent to the parties, whether or not he has reviewed the entire record and all of that. But when we get to that point in the hearing, I think that would be the appropriate protocol.
Thank you. Ms. Middleton?
Yes, just briefly, I'd like to raise 3 points. There's no question that Mr. Lopez engaged in inappropriate behavior and used poor judgment. As a 19-year employee, he should have used better judgment. Section 12057 specifically says that you as the agency have the responsibility, the primary responsibility, to interpret statutes and rules within your regulatory authority and your expertise. Policy 3.02, as well as Florida Administrative Code 6A10-081 are within your purview. This was not a criminal allegation. The respondent spent a great deal of his time talking about there not being any malice or intent. The allegation is that Mr. Lopez engaged in inappropriate horseplay, inappropriate interactions and comments. It is for these reasons that you should accept the exceptions and grant the exceptions and uphold the termination. Thank you.
Thank you. So before we go on to the vote, first I'll ask Mr. Ferguson, have you had an opportunity to review all of the records?
Yes.
Okay, so I will ask both parties. Ms. Middleton?
I have no objection to his voting.
Mr. Sewell?
No objection.
Okay, thank you. So then we will have you participate in our vote, Mr. Ferguson. So the board will now rule on each and every properly filed exception. Do we have a motion on the exceptions? Okay, we don't have a motion from the board, so then I will actually, oh, do we have one?
Thank you. I would like to make a motion to deny all of the petitioner's exceptions, to accept the exceptions from the superintendent.
I'm sorry, can you repeat that?
I would like to make a motion to deny all of the petitioner's exceptions and accept the recommendation of the superintendent for termination.
Motion by Mrs. Whitfield. Do I have a second?
Did I say that wrong? I'm sorry. I'm sorry. I was looking for the file to be able to say it. Oh, sorry, the petitioner superintendent. I'd like to make a motion to deny all of the respondents' exceptions and accept the recommendation of the superintendent for termination. My apologies in saying it wrong.
Do I have a second?
He didn't make an exception.
Mrs. Bernard?
Can I just, as a point of clarification and correction, only the superintendent has filed exceptions, and so I think I understand what you're attempting to do, so if I may suggest that if it is your intention to agree or uphold the termination, which is the request of the superintendent, then what you would be asking is to grant the exceptions filed by the petitioner.
I apologize. I was looking for the page and I didn't see the wording specifically, so it's going off the top of my head. So yes, I would like to do that.
Do we have a second? Seeing that we don't have a second, that motion fails. Ms. Ayala?
Thank you, Madam Chair. I'm going to make sure I'm reading our memo. I move to deny the petitioner's exception for exceptions 1 through 4 and grant, can I combine them? And grant the exceptions 5 through 7.
Motion by Ms. Ayala. Do we have a second? Second by Mrs. Andrews. Any discussion? Okay, I will just add that I'm going to vote against that motion because I would believe that the ALJ was correct in the findings. I believe that the ALJ's recommendation for structured disciplinary action aligns with the intention of preserving an educator's career. So I will vote against that. Any other comments? Okay, we'll take a vote. All in favor of the motion? I can't see everybody. Mrs. Whitfield, are you in favor? Okay. Mr. Ferguson? Okay, so in favor we have Ms. Ayala. I can't see Mr. Barbieri. Are you in favor? Okay, I couldn't see you. Mrs. Andrews? And anybody else? We have 3 in favor. All those opposed? 4 opposed. Motion fails. Do we have another motion? So I would like to make a motion. Do I need to turn the meeting to, so I'm going to give the gavel over to my vice chair, Mrs. McQuinn. So I move that the board deny all of the petitioner's exceptions and adopt the recommended order as the final order and authorize the general counsel to prepare a final order reflecting the board's rulings to be brought at the next meeting of the school board.
Is there a second to Chair Brill's motion? Mr. Ferguson, second. Discussion. Ms. Ayala.
I cannot support that motion because there are findings of fact showing that we are within our authority to make a determination about the behavior exhibited by the employee.
Ms. Andrews.
Yes, I will not be able to support it either. You know, I do believe in our long-term employees, but I do believe in progressive discipline. I do believe that we are following the contract as it relates to working with our employees, giving them an opportunity to improve the behavior. And as I read through the report, with 19 years experience and for the continued practices that were very unprofessional it just doesn't work well with me to support that. So there was enough in the reading for me to deny. And I think the superintendent's recommendations, the petitioner for 5, 6, and 7 grants me the privilege to deny the employment of this individual.
Ms. Whitfield?
Thank you. I just, I spent a lot of time thinking about this because I did really take the ALJ's comments into consideration. But I feel that, being at this district for the last 15 years, it is so rare that someone is terminated. And I believe that this is something that when it finally does get to this point, it is our responsibility as a board to stand up for our principals and our staff that worked so hard to be able to get to this point in progressive discipline. So that's why I wanted to make sure that we upheld the superintendent's termination, because I believe that was not come to lightly, and I don't believe that we get to that point quickly. So I will not be supporting Chair Brill's motion. Thank you.
Anyone else? I'm going to add a comment. I have frankly gone back and forth with how I feel about this, and I wrote down the piece about my expertise because I do have many, many years of expertise in evaluating teachers' performance and their interactions with students. Not that many with middle school students, although some. And I had to ask myself, would I be comfortable if I had a child or a grandchild in your classroom? And the answer is no, unless there was a principal who could be in the classroom every day making sure that you were not behaving inappropriate. So I've gone back and forth even tonight with this. So ultimately, first of all, I thought the judge's orders were very well reasoned, which is initially why I was going to agree with the judge's recommendations. But when it comes down to it, when we talk about safety of students, we're not just talking about physical safety, we're talking about emotional safety. And a teacher is a figure of authority. So students may feel uncomfortable speaking up when they do feel uncomfortable. So ultimately, I'm going to support the superintendent's recommendation. But I want you to know that I spent many, many, many hours thinking about this. And one more thing, I'm so sorry. I did have my points written down, is that when it was already known from before the suspension, I don't know why I would believe now that it would be taken any more seriously to be given a second opportunity. Thank you. Anyone else? Okay, we are going to call for a vote, and I know this sounds ridiculous, but may we please have Ms. Chair Brill read it one more time?
Okay, so I move that the board deny all of the petitioner's exceptions, adopt the recommended order as the final order, and authorize the general counsel to prepare a final order reflecting the board's rulings to be brought at the next meeting of the school board.
So all in favor of that motion? I see one, Ms. Brill. Nays, please raise those hands high. I see 6 nays, including myself. Ms. Whitfield?
Could I try my motion from before again, but this time with the appropriate wording? Maybe we'll see if it gets farther this time. Okay. I move that the board grant.
So we are going first. So first of all, the motion fails. So now I'm here, Ms. Whitfield, making. Oh, I'm sorry. Now I can turn this over to Ms. Brill, Chair Brill.
So To the board clerk, you have that motion fails 6-1. Okay, Mrs. Whitfield, you may continue.
Thank you. I move that the board grant all of the petitioner's exceptions based upon a complete review of the record and the reasons and citations set forth in the petitioner's exceptions document and articulated by counsel at today's hearing, and that the board authorize general counsel to prepare a final order reflecting the board's rulings to be brought at the next meeting of the school board.
Do we have a second? Mrs. Andrews seconds. Any discussion? Mr. Barbieri.
It's my understanding, talking to the general counsel, that if we grant the petitioner's exceptions 1 through 4, that we are, excuse me? If we grant the petitioner's exceptions 1 through 4, we are outside of our authority, which would, on appeal, be reversed, and we would then be subject to all of the attorney fees based on not only the appeal, but this attorney's preparation for this hearing. So I cannot support the motion because we're outside of our authority to grant exceptions 1 through 4 because they are findings of fact, and we do not have the authority to question the findings of fact that are adequately supported by the record as determined by the judge. Which leads me to this question. I don't understand why the petitioner's attorney would present to us exceptions that she should have known that this board did not have authority to grant because they are findings of fact, because the general counsel is telling us that we do not have the authority to grant exceptions 1 through 4 because they are challenging findings of fact that are supported by the record.
May I respond, please?
Before you respond, Mr. Barbieri, would you like to propose a substitute motion? Amend the motion?
I'll amend the motion. A substitute motion would be to deny petitioner's exceptions 1 through 4 and grant exceptions 5 through 7.
Do we have a second? Second by Ms. Ayala. Ms. Middleton?
Upon legal research and reviewing the 4th District Court of Appeal decision in the school board, Latson versus the school board, if the conclusions of law are imbued with policy statements and findings of fact, in this case, the recommended order in paragraphs 85 through 110 repeated some of the findings of fact from the earlier sections. And reading that appellate decision, that is conclusions of law imbued with policy decisions. The whole discussion regarding the progressive discipline was a policy decision. That is set forth and embedded in our collective bargaining agreement. That's policy. So the mixing of the finding of fact along with her conclusions of law in my reading of the Latson opinion, then you have the authority to, and I will read the language specifically. And they quoted 120.571L authorizes an agency to reject or modify an ALJ's conclusions of law and interpretations of administrative rules over which it has substantive jurisdiction. And that was in the conclusion of law. You as an agency have the primary responsibility to interpret statutes and rules over which you have regulatory jurisdiction and expertise. As it relates to the collective bargaining agreement and progressive discipline that was negotiated between us and the CTA, that is an area that you have, you as the board. And when that is imbued in the conclusions of law, I believe that the Latson case allows you to make that. It also says when rejecting or modifying such conclusion of law or interpretation of administrative rule, you can find that your substituted conclusion of law or interpretation of administrative rule is as or more reasonable than that which was rejected. So that is why I brought exceptions 1 through 4.
Madam Chair?
Before you go on, Mrs. Andrews, you had wanted to say something? Okay, Mr. Barbieri.
Madam Chair, I'd like to ask the General Counsel, if I might. General Counsel, you told us in your memo that we cannot grant the petitioner's exceptions 1 through 4. So is that attorney correct, or are you correct? Advise the board whether or not we have authority to grant exceptions 1 through 4.
Well, as an advocate for her client, she is correct in advocating for her client. And I'm not in a position to speak to the advocacy because it would be unethical for me to have engaged in any communication with her during this process. So she is absolutely correct in her advocacy, just as Mr. Sewell is correct in taking whatever efforts and making whatever efforts he has made to advocate for his client and presenting those before this board as a quasi-judicial fact finder and will be conducting the conclusions of law in this proceeding. So from that perspective, I really can't comment on the advocacy aspect of it. My role is to advise the board as it sits as a quasi-judicial at this stage in the process. And so our review of it, my review of it, is that there is risk and certainly potential exposure to the board for engaging or stepping into the shoes of the hearing officer when it comes to the factual findings. Could the board depart from that and decide from hearing the argument today to grant the superintendent's exceptions in their entirety? Absolutely, the board could do that. But I will still stand on that it would be risky for the board to do that. It's ultimately up to the board, but there could be some risk in doing that.
Mrs. Andrews?
Thank you. And I really did spend quite a bit of time talking with the attorneys. And Mr. Barbieri, I do hear you when you indicate that from the discussions with our attorneys, 5, 6, and 7. I love 6. But the first 4, I think it's a little bit more geared to interpretation. I do believe in the progressive discipline piece, that we do have the authority to accept every last one of them. But as I read through the ALJ's recommendations for 1 through 4, I felt like it was a little bit more not as tight for me. And this is why I felt really good about 5, 6, and 7. I truly loved 6, but I could live with 5, 6, and 7. So that's what I can support.
Mrs. Andrews? I'm sorry, Vice Chair McQuinn.
So what is our motion on the floor right now?
Mr. Barbieri, can you read the motion?
To grant, to deny petitioners exceptions 1 through 4 and grant petitioners exceptions 5 through 7.
Okay, and I, again, in opening us up to what I'm concerned might be further legal action, I am not going to be able to agree with that.
Mrs. Whitfield.
So just to recap, I put a motion on the floor that was to support all 7 of the superintendent's motions. There's not been a second on that yet because we had Mr. Barbieri come forward. Then Mr. Barbieri actually restated a motion that Miss Ayala had said before, and that died. But I do think we need to bring it back up again because I think it is the best opportunity. And so when he was saying that, I would like to give a second to his motion because I do believe it's the direction that this board should go now. Does that make sense?
Mrs. Whitfield, just to correct the record, Ms. Bellata, we did have a second. Who was the second?
For my motion?
Yes.
Yes, there was, you were seconded by Mrs. Andrews, and then
we had
there was discussion, and then to ask to amend the recommendation by Mr. Barbieri.
Okay.
Submitted an amended recommendation.
Mr. Ferguson?
Chairperson Burrell, I just wanted to direct a comment to Vice Chair McQuinn. Vice Chair McQuinn, I think Board Member Barbieri said that denial of 1 through 4 will close us off from attorney fees. So just please correct me if I'm wrong, because I think what you said was that you were not supporting his amendment to the motion because it would open us up to fees, but it sounds like General Counsel has confirmed that her position, which was echoed through Mr. Barbieri, is that if we deny 1 through 4, there's no exposure potentially to us as a board to attorney's fees. Thank you, Madam Chair.
Madam Vice Chair.
Thank you. All right, so I get that, and thank you, Mr. Ferguson. So I want to go back to our general counsel again. I'm hearing that we can leave 1 through 4 alone. We can grant 5 through 7, I'm correct. And that is what I believe Mr. Barbieri was proposing. Okay, thank you. And I'm so sorry, General Counsel. Do you have any response to that at all?
I do not. Only that I believe the posture that we are in is that there is a substitute amended motion on the floor. Do I have that correct, Ms. Blunt? Okay.
Okay, Mrs. Whitfield, we have a substitute motion on the floor. You've spoken twice, so we will need to take a motion to suspend the rules and continue the conversation.
I was just going to pull back my motion and get rid of it.
So you're withdrawing the original motion. Okay, so now the motion on the floor. Mr. Barbieri, do you want to read it one more time?
I move that we deny petitioners exceptions 1 through 4 and grant petitioners exceptions 5 through 7.
Okay, before we take the vote for discussion, I'm just going to add that I do support your withdrawing 1 through 4. I will vote against it, though. Again, I don't believe that having Mr. Lopez in the classroom is going to make our classroom unsafe. I read through all of the records, and I do agree with the ALJ's recommendation for a structured disciplinary action comprising a suspension, probation, professionalism classes, and specific behavioral directives, which aligns with the intention of preserving an educator's career while ensuring the safety and well-being of students. So while I will vote against this, I just want to make sure it's known that I do support the well-being of our students, but that I do agree with the administrative law judge. So, Ms. Andrews?
And I'm just going to repeat it again because I do have high expectations for all of our professional employees. I do believe in our contract with with progressive discipline. And, you know, when you have actually worked through warnings, suspensions, and getting to the level of termination, and then when I just read about all the things that were happening in that classroom as a former teacher, it really disturbs me, and this is why I have to stick to it. I worry about any child that's going to be in that class again after all of these levels of support has been given to our employee, and we're sitting here today saying another chance. I think our Classroom Teachers Association, along with the school board, works hard on putting the contract together to make sure that we give teachers an ample opportunity to improve, to do better. And so sitting here as the final judgment, I cannot, in all honesty, vote to bring someone back after we've given so many chances.
Okay, so we'll now vote on the motion. All those in favor? All those opposed? Motion carries 6-1 with Mrs. Brill, Chair Brill opposed. I now will need a motion to authorize General Counsel to prepare a final order reflecting the board's rulings to be brought at the next meeting of the school board. May I have a motion, please? Motion by Mrs. Whitfield, second by Ms. Ayala. All those in favor? All opposed? Motion carries 7-0. Thank you. Okay, we'll now conclude the hearing. May I have a motion to adjourn? Okay, motion by Mrs. Andrews, second by Mrs. Whitfield. All those in favor? All opposed? Motion carries 7-0. Actually, no, we're going into the